Oh yeah, come on in. Don't be shy, don't stall. We got a funky vibe, yeah. Welcome all. It's a safe spot where the truth unwinds. Share your thoughts, leave your worries behind. Woo! Defense West, that's where you belong. Click that like and groove along. Hit subscribe, let the love flow free. Join the fam where you're meant to be. Oh, got mysteries, stories that thrill and ride. We dig deep, ain't no secrets to hide. No judgment here, just an open crew. We're all about justice and the honest view. Yeah, Defense West, that's where you belong. Click that like and groove along. Hit subscribe, let the love flow free. Join the fam where you're meant to be.
Well, howdy, howdy, howdy. Welcome. Oh, there we go. Now we have a background. I had to. Aww. Look at you go. You just showing off now, aren't you? You just piling it on. I actually had to go in and change my intro and outro and everything again. I haven't used it for so long. But welcome, thank you. I thought it was time for a palate cleanse, and I was watching this hearing this morning, and I actually found it really, really interesting. The arguments that the attorneys have put forward to the Supreme Court. That's I thought let's watch it together, because why the fuck not? We can. Yeah, the reason I say Miss Tricia is showing off is I opened my mail yesterday to a beautiful card that she'd sent to Liz in North Carolina and Uda Hef in Florida, and they'd all written some beautiful messages for me and sent it, and I got it yesterday. So yes, you're in trouble, Miss Tricia. It was beautiful, thank you. You ruined my mascara for the rest of the day. Yes, so it was an impromptu today, so hence why there's no camera, because you don't really want to see this, trust me. I haven't even done my regrowth, which you put me. Yes. I'm actually going to change the memberships up and make it just one, not three. So I think I'll leave it at, like $2.99 a month or something, and just have one across the board. I think that's easier. We got the Gulf Coast covered. Alrighty. So let me set this up. I've got the have you guys seen it? As it only came up. Oh, and a big shout out to the Trial Channel for the coverage. It's a ripper copy. And I'm going to put a poll up while we're watching it, a poll up in the chat, just to see what your thoughts are, because I actually think they've got a bit of an argument, just quietly. Let's see what you think. Alrighty. Now oh no, we don't need that. We don't need to see me. How's that? Does that look all right? That'll do. Let me know if you can hear it. Ready, please, Mr. Music.
Good morning and welcome to the First District Court of Appeal. We have one case on the docket today, Charles ADELSON versus State of Florida. Counsel, when you're ready, you may proceed.
Good morning. Please the court.
Michael
Lefton on behalf of the appellate, Charlie ADELSON. Seated with me at counsel table is co-counsel Laurel Cornell Niles. I'd like to reserve 5 minutes of my time for rebuttal.
So noted.
I'm hoping to focus the beginning of my time this morning on the first two claims, which are the jury selection claims, and I think they're intertwined. And then
there's three. There was 150 jurors apparently polled in this jury pool, and they divided them into three groups of 50, and it's the middle group of 50 that he mainly concentrates on regarding their honesty and their exposure to social media and bias.
I also intend to briefly address ground three. So let me begin with the jury selection claims. Claim 1 concerns the trial court's failure to grant the motion for a change of venue. Claim 2 concerns the trial court's failure to strike the panel, and then specifically, as that issue evolved, to strike the middle group of jurors 51 through 102, for reasons that I'll get into in a second. Let me begin with the change of venue argument. The numbers in this case are pretty striking. We know that of the 130 jurors who were questioned individually, and that's the way this process went. The judge began jury selection by individually questioning jurors in groups of 50. There were 3 total groups that were ultimately questioned to determine whether or not they've formed an opinion about the case and whether or not they've been exposed to pretrial publicity. Of the 130 that were questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they were excused for cause,
They all
correct?
were.
All right, so let's start a little bit about the procedure that the rules require before those interview questions are even asked. Why don't you address, the rule requires a written motion, an affidavit, and a good faith statement, correct?
Yes, Your Honor.
All right, and that didn't happen here.
No, Your Honor.
And what type of things would we have seen in an affidavit before any jurors were interviewed?
I don't know. And my response to that is, and I understand that I'm attacking the rule and it's a requirement, although there's certainly case law that says that if a motion in any context is made orally, and if there's a component within our criminal procedure rules that requires it to be written, if it would be a useless gesture for such a motion to be submitted in writing when it's been thoroughly discussed and ruled upon orally, then that's not required. And I think that, again, specifically applies to this type of case. We know the Florida Supreme Court has been very clear that change of venue claims almost always need to be considered during jury selection, that a judge is not going to grant a change of venue claim pre-trial.
Sure. But one of your arguments is that the Tallahassee community, almost 300,000 people, was so tainted by what you characterize as pervasive media that there could be no jury selected that would be impartial. And wouldn't affidavits have shown, for instance, that, what types of media that the citizens of Tallahassee in this community were consuming? And you definitely see in the record the local sources, national sources. You make the argument that this isn't like the 1994 trial of Danny Rawling in 1994, where people would watch Dan Rather or Tom Brokaw. And I think that's right. But wouldn't the affidavits also have shown that maybe consumers curate their media differently? We saw in this transcript, there were many consumers of media who said, I'll give some examples. They don't watch television. I turned off my propaganda box 3 years ago. I don't read the paper. That's for wrapping mullet. Very rarely do I watch the news. And so you see a lot of behavior in this typical kind of Tallahassee community that's different than 1994. Couldn't you have shown those things in an affidavit before you interviewed a single juror?
So clearly, the rule says that should have been done, and I'm not disputing that it should have been done, but I submit that it was established by the record as you just indicated. The record very clearly shows the way that the 130 jurors that we're talking about consumed their information about this case. And it's not just, contrary to what happened in 1994, what was happening in the 90s, it's not just the print media. Clearly, the Tallahassee Democrat covered this case extensively. It's not just the local news. Clearly, the local news covered this case extensively. But unlike the 90s, now we have several jurors saying that they're getting their information from cable news networks, Court TV, shows
YouTube, Court TV, 2020, Over My Dead Body podcast, The Preston Scott Show, Tallahassee Democrat. But what you don't have in this record is how many times those exposures happened, whether they were biased or not, whether there were some broadcasts or podcasts that in fact argued that your client was innocent. We don't have the content of that to show how that would have influenced the veneer, correct?
We do not have that from affidavits pre-trial showing the things that you just mentioned, but we do have that in the record based on the answers that the jurors gave. And again, when we are talking about a little over 40%, that's a huge number. In the Murphy case, I believe it was right around 25%. And in that case, the court said that's not enough. Here we are at 40%. So when you talk about 40%, when you talk about the judge making a finding when granting the protective order pre-trial that Tallahassee is in fact a small community, when you talk about this case has been permeating Tallahassee media sources for almost a decade at the time of this trial, when you talk about there was 3 previous prosecutions, one of which resulted in a mistrial and a subsequent trial just a year before my client's trial.
Sure, but why don't we talk about what the Florida Supreme Court says when there's pervasive media? Certainly, no one would argue that there wasn't pervasive media in the Danny Rowland case, right?
Correct.
We're talking about 5 murders, college town, again, maybe a small community as you would describe it, perhaps.
Sure.
So with that, since that case, in the Ellerby case, the Armstrong case, the court has said that it's not enough to show that media was pervasive. It was, could the juror be impartial? Every single juror seated in this case said that no matter what contact, many of them had no contact with media or information, that they could be impartial. Isn't that right?
That's correct.
All right. So specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief. The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do we do with Armstrong?
So two responses to that, 3 actually. Just quickly regarding my client accepting it. I don't know that my client accepting it matters much. I think the concern is did defense counsel renew the objection? The state made an issue out of that. And if you look at the question asked of my client at the conclusion of jury selection, the judge literally says, you have no choice but to accept because you have no strikes left.
But was there an objection?
Was there an objection? I understand. But again, so that I'm just responding to the concern. I understand the state raised it, and that's probably why you're saying it. But my client accepting the jury is irrelevant to this matter. The question is, did defense counsel renew the objection? I acknowledge that generally is what's required for any type of jury selection claim. However, Manning is specifically a case where we know from the dissenting opinion the request to change venue was not renewed.
But I'm going to repeat, Manning was decided 24 years before Armstrong in 2003, where the Supreme Court specifically said the failure to renew is waiver of the claim.
I understand.
Sorry, I was busy typing out my poll and didn't see the chat. Yes, Child Channel is the best. The guy behind the attorney is Tim. He goes on STS. STS. I can't remember the name of that. STS. Oh, I've got a blank on that. You have to write the proper name in chat so I can remember it. Behind the attorney. The brunette behind him is Abby King. Is she in the grey or is she in the leopard skin? Leopard print. Abby Crossing, sorry. She was chatting in the chat while in court and Joel was reading Hey, Jenny. How you going, love? Hey, Christine. We don't know yet, darling. This is his attorney's putting his argument to the Supreme Court to have an answer. There is a couple of good arguments in there, though, I might say. I highly doubt it as well, but yes. This appeal is but round. Okay. Okay. Ineffective counsel. All right. Who else has got an ineffective counsel? Did his attorneys coerce him and torture him and convince him to make a guilty plea? Yes, I've pinned a poll in the chat. Let's have a look and see what your opinions are whilst we go through this, and we'll evaluate it at the end. You might need to remind me though, because I'm shit like that. What's that? Don't be like me and make sure you change chat. You almost yes. I have to do that every time. All right. Surviving a survivor. Okay, yep, cool. Thank you. She's in the grey. All right. So it's that lady just... No, you can't see my cursor.
Now, here.
And now, there you go. This one here. All right. Where are we up to? Just there, I think. Where are we? We're not 10 minutes in, surely.
record based on the answers that the jurors gave. And again, when we are talking about a little over 40%, that's a huge number. In the Murphy case, I believe it was right around 25%. And in that case, the court said that's not enough. Here we are at 40%. So when you talk about 40%, when you talk about the judge making a finding when granting the protective order pre-trial, that Tallahassee is in fact a small community. When you talk about this—
Is there anyone that doesn't turn that off? The ones that don't know it's there, obviously, but anyone else? No. It's useless.
This case has been permeating Tallahassee.
Oh, while we're on that, Simi, I don't know if you saw it, but I got an email from YouTube saying that my Martin Bryant stream breached copyright and couldn't be monetized. But I got that email 3 hours before I went live. Before I even fucking done the video, like done the live stream. So who's censoring YouTube and Martin Bryant?
Media sources for almost a decade at the time of this trial. When you talk about, there was 3 previous prosecutions, one of which resulted in a mistrial and a subsequent trial just a year before my client's trial.
Sure, but why don't we talk about what the Florida Supreme Court says when there's pervasive media? Certainly no one would argue that there wasn't pervasive media in the Danny Rowland case, right?
Correct.
We're talking about 5 murders, college town, again, maybe a small community as you would describe it, perhaps.
Sure.
So with that, since that case, and
all right, here we go. There you go. Oh, I didn't reject it, but yeah, the bottom one there that says YouTube video cannot be monetized. Seascape Port Arthur, 7:48 p.m. And then you go out where the red dot is. That's when I went live 3 hours later. A-holes. Yep.
the Ellerby case, the Armstrong case, the court has said that it's not enough to show that the media was pervasive. It was, could the juror be impartial? Every single juror seated in this case.
Someone in the Australian federal government or the Supreme Court in Tasmania have put a gag on it basically until 2099. So there would be a red flag on anything because it's starting to gain some momentum. Anything that comes across and flags Martin Bryant or the Port Arthur massacre, they're censoring it obviously, and that they've been given that directive to YouTube. That's all I can think of.
He said that no matter what contact, many of them had no contact with media or information, that they could be.
Did those emojis come up? Or is it just the, like, can you see those personalized emojis on there? Because it's coming up as just written bullshit on my screen. Hopefully you can use them. I think they were fun.
Partial. Isn't that right?
That's correct.
All right. So specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief. The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do we do with Armstrong?
So two responses to that, three actually.
Yep.
Quickly.
Oh, it's flagged. They flagged it. It has to be. They tried to take Paul down, and he had to change his what did he have to do? He had to change where he was streaming it from, I think, because that's what they do. That's what they do. That's how they control us. They limit what you can share. If it's information that might damage their agenda, their narrative, then, well, let's not share it, and then they won't know any different. Hello?
Regarding my client accepting it, I don't know that my client accepting it matters much. I think the concern is, did defense counsel renew the objection? The state made an issue out of that. And if you look at the question asked of my client at the conclusion of jury selection, the judge literally says, you have no choice but to accept because you have no strikes left.
But was there an objection?
I understand. But again, so that I'm just responding to the concern I understand the state raised it, and that's probably why you're saying it, but my client accepting the jury is irrelevant to this matter. The question is, did defense counsel renew the objection? I acknowledge that that generally is what's required for any type of jury selection claim. However, Manning is specifically a case where we know from the dissenting opinion, the request to change venue was not renewed.
But I'm going to repeat, Manning was decided 24 years before Armstrong in 2003, where the Supreme Court specifically said the failure to renew is waiver of the claim.
I understand.
That's precedent that's binding on this court, is it not?
The court doesn't, we're all familiar with the principle that a court doesn't overrule itself sub silentio. The court has not specifically said Manning's no longer a good law. That being said, I rely upon Manning because it was ultimately reached consistent with what I think the U.S. Supreme Court has said is an appellate court's burden to go through the record in one of these cases to determine if there's a change of venue issue. But beyond that, I will acknowledge that at the very least, to the extent that this court finds that it's not preserved because it was not renewed, then the question is it fundamental error? And I submit that based on the facts of this case, we do meet the fundamental error standard. In the Smith case just 4 years ago, the Florida Supreme Court specifically said that the failure to preserve a change of venue claim can nevertheless be reviewed under the fundamental error.
Well, my understanding is, the reason we have this very, very unusual requirement for, a renewal of an objection is not just simply, it's not just Simon says, just, you got to do it twice or else. It's that it is possible that the defense is happy with the jury. It's generally in the challenge context when you challenge a juror and they want to see whether you renew that challenge, that you are in fact satisfied with the jury. So I don't know if you can say that it's a fundamental error issue if in fact the defense was satisfied with the issue.
A couple of their arguments are now, one was is the jury pool tainted, and now they're going for fundamental errors.
Now, I did believe when I saw Armstrong, it's like, wait a minute, it's not what happened in Joyner. It's not a cause challenge, it's change of venue.
Correct.
But when you read Armstrong, it's very clear. First of all, it says that a change of venue motion is premature until you actually attempt to select a jury. What
Correct.
that says to me is a change of venue is a jury selection issue.
Sure.
And what I draw from that is that, just as Judge Rowe is saying, if you in fact are able to find jurors who swear that they are untainted, then I don't know if there is in fact a change of jury issue. It very well may be that the defense thinks, okay, I found untainted jurors. I don't really have any reason to continue with the change of venue objection. So that raises two things. Number one, whether the fact that you have untainted jurors overcomes the fact that the community may have had a low level of taint. And number two, the suggestion that it's fundamental error when the whole point of the objection is that the defendant is satisfied, which I don't think a fundamental error claim can overcome.
So a couple of responses to that. Again, the Smith case is 2021, and it's specifically page 28 of the Florida Supreme Court's opinion. And they clearly went on to address the claim for the change of venue motion, despite the fact that it was not preserved. And they did so under the fundamental error standard. And so I'll quote from the case.
But isn't there a difference between preservation and waiver?
Sure. Well, yes, but
Yeah.
So if we're going to waiver, and now if you're addressing what my client said at the conclusion of jury selection, that's no waiver on my client's part when the judge specifically told him, you have no choice.
I guess perhaps I should just read Armstrong again, because Armstrong says a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. So it is the failure to object that is the waiver in this context.
So that's how when they say at the end to preserve the record, they need to put in that appellate court application within the time frame. That's what she's talking about.
I mean, do you read it any differently than I do?
If that were the case, then Smith in 2021 would be wrong. And Smith obviously is more current and specifically says that because the issue was not preserved, because it was not renewed at the conclusion of the jury selection proceeding, we review this claim for fundamental error. So I submit to you, again, this court has the ability to review the claim. Smith from the Florida Supreme Court very recently has said, for at least a change of venue claim. It may be different for a peremptory challenge, the failure to grant a cause challenge. But when it comes to change of venue, the Florida Supreme Court has specifically said it could be reviewed for fundamental error. And I guess going back to Manning, and I understand the time difference, but Manning would be a great example of that. You literally have the attorney in Manning saying at the conclusion of jury selection, I believe we picked a fair and impartial jury. And I submit that there's no jurist in this state that would review the facts and reach a conclusion, unlike what the Florida Supreme Court did, that there's no way that venue could have been fair within Columbia County in that case. So that's exactly why these claims can still be reviewed for fundamental error.
Just generally speaking, normally when we talk fundamental error, it's because that an error wasn't preserved below. Can
Correct.
Fundamental error be affirmatively waived?
If defense counsel had said, if the question rather than to Mr. Adelson, do you accept this jury? And let me point out, you have no choice but to accept the jury, but answer me anyways, do you accept this jury? If it had been defense counsel, you previously raised some objections. Do you now no longer renew those objections and accept this jury? If that would be the case, I would have no ability to make an argument in front of you today. That would be waiver. That's not at all what we have in this record. I think the
Well, it
facts.
sounds to me like you're going up a 3850 avenue.
38.
Let me ask you this question.
Why not
Is
3850?
Armstrong's a 3850 appeal.
Correct.
The other cases we're talking about earlier were direct appeals. Is
Correct.
that distinguishable?
Perhaps. I mean, again, a lot of times when the Florida Supreme Court considers 3850s, they also consider 9.141s in the context of failure to raise issues on direct appeal. And that's also the way, in Hilton at least, that the ways these claims are being raised. But again, in a direct appeal claim, on a direct appeal, the issue is it preserved? If it's not, can it be reviewed for fundamental error? I submit that there are some things that cannot be. Generally speaking, the failure to renew a cause challenge is not something that's going to be reviewed for fundamental error. The court's been clear about that. And if there is a specific waiver on the record, we don't have that here, then no, you wouldn't be able to review it for fundamental error. Waiver trumps fundamental error. We don't have a waiver here, and I submit that fundamental error is still the standard.
But surely you're not arguing that now a trial judge has to, who's represented, a defendant's represented, now a trial judge has to look to the defendant who's represented by counsel to say, do you individually accept a jury?
I have no idea why the judge did that in this case. But it's
But are you promoting a bifurcated question by a trial judge to counsel and a defendant?
I think in the context that the judge is asking the question in this case is it fairly could be construed as, do you have any other strikes? And that's why, and every time that question was being asked, there was a strike because there were back strikes in this case. So ultimately, when he just asked the same question he'd been asking up until that point, the question was, do you accept this jury, i.e., do you have any other strikes? And I guess let me throw out there, you have no other strikes, so you have no choice but to accept the jury. That's why it's being said here. Again, I acknowledge it's incumbent upon defense counsel to jump in and specifically say, we renew the objection, but if that's not done, it's still reviewed for fundamental error. I see that I'm getting my rebuttal time. I would like to make a couple other quick points
Counsel,
about the merits.
I'm going to extend your time by 5 minutes. I'll do the same thing for the state.
Thank you. I appreciate that. I do need to address. So we have, and I've already talked about this, the almost 40 or a little more than 40%. We have the Tallahassee community. We have the different ways that social media infects jurors in a community now. But we have more than that in this case. In Patton, the U.S. Supreme Court said exactly this: adverse pretrial publicity can create such a presumption of prejudice in the community that the jurors' claims that they can be impartial should not be believed. The U.S. Supreme Court is saying that
And they're saying that, and they probably are saying that on a record where there was a record that the media exposure was indeed adverse.
Well,
And
but-
again, we can't presume that,
Let
can we?
me go further with that, Your Honor. What they're saying is there could be such intense media influence in a case that we may not even believe what the jurors are saying. And if I came to you with no evidence in the record and said, that's what we have here, you'd say, Mr. Rufferman, you're speculating. We have 2 instances where jurors lied directly to the trial court. Ask
So are
point
we
blank.
supposed to just
I don't know.
assess the credibility of these jurors? Is that what an appellate court is to do under this theory?
No, but what we have in this record is 2 instances where jurors were specifically asked, have you formed an
No,
opinion
Your Honor.
about guilt in this case, or have you posted anything on social media about this case? In both instances, the jurors said no. In one case, thanks to good defense counsel, good lawyering, they had a couple of posts from that juror and presented them to the trial court where that juror had said that the parents of Professor Markell should assist in killing Mr. Garcia, and then went further when my client was charged and said, surprise, surprise, Mr. Adelson is charged. But the worst one is by far the next one. Mr. T is how I refer to him, as the first initial of his last name. Mr. T stood in front of the trial court and when asked, have you formed an opinion about whether or not this defendant is guilty? He point blank told the court, no. Lo and behold, 2 jurors later, Miss M comes in and by happenstance is asked the question, has anyone been discussing this case amongst the jurors? Oh, why, yes. In fact, that gentleman that was just excused with the glasses, what's he been saying? He's been going around telling other jurors that Mr. Adelson is guilty.
And both of those jurors were excused for cause, were they not?
Yes, but statistically, if those two, it's very hard to prove someone's lying. Usually you rely upon some luck or some good lawyering with coming up with the post. So we know that one juror reported the other juror, and that's how we know that juror was lying.
And then being careful, defense counsel was offered the opportunity to review the tapes of the jury assembly room to see what comments were made, what are the reactions of the other jury members, and defense counsel said, no, I don't want to see it.
But here's the problem with that. And going to the second claim now. The second claim is a very specific, easy fix. We know for the second group of 50 jurors, 51 through 102, problems were happening. We know about halfway through jury selection, it's reported, number one, that jurors have not followed the judge's direction. So much so that the judge, when he heard about this, after 2 of the jurors reporting that the jurors have been talking about the case, goes out and admonishes those jurors pretty sternly, do not talk about this case. But we also know—
But the problem is the content of those communications. And they were like this, high profile case. It's the Charlie ADELSON case. It's the Dan Markell case. Which of the, and that he's guilty. But again, the trial court offered your client the opportunity, the defense counsel, go listen to the recordings in the assembly room and you can bring back some statements that would in fact taint the jury. How did these statements taint the jury?
We have 4 statements, right? So we have one where a juror said, we've been talking about it all day, is literally the quote. We have another where there's some pretty—
Talking about it, I mean, content. Let's get to the content.
Talking about the case all day.
Again, but that you could have questioned those jurors to get specific information on what content tainted the jury.
Okay, that's one juror. A second juror then said that there had been a lot of talk about he's a professor at the law school and revealing a lot of the facts about the case. There was a divorce going on between the professor and the wife, but the 2 that are far the most concerning are the 2 jurors that specifically went back, a male and a female, the one with the glasses and then an older female that went back and told the other jurors he's guilty. In fact, if you look at juror C, on page 2581, you have, and coincidentally, when she's asked, after she reports that she's heard that this female juror is saying that he's guilty, oh, what's your opinion? I think he's guilty too. This is influencing the that set of the panel. So we have 4 statements. Let me come back to why I think this was an easy fix. There was 3 groups of 50. It was clear 8 of the jurors that sat on the jury came from this middle group, 51 to 102. At the midway point, the judge admonished the jurors to no longer talk about the case again. And the judge said, from this point forward, every juror, we should ask them, have you been discussing the case? Of those 8 jurors that came from the middle group, 4 preceded those 2 things. So for those 4 jurors, we have no, and I can quickly tell you the page numbers regarding those. I have the names. I apologize. I will say them. It's Brazos, 2467. It's Kraft, 2497. Milne, 2514. Hawley, 2528. Those 4 jurors were all exposed to
somebody saying, I think that the defendant is guilty.
Yes, multiple
So-
times.
Okay, so they rendered that, so you have jurors who probably shouldn't be serving and didn't serve, is my understanding.
How many other were influenced by that?
Expressing their opinion that the person was guilty. But don't we typically, we're going to strike a panel or require the striking of a panel when facts come in that would otherwise not be admissible? Isn't that the typical standard for striking a veneer?
Strike 50 jurors, just those 50. The clerk actually
That's fine,
said,
but the reason for it isn't that somebody has rendered an opinion as to the guilt of the defendant. It's whether they've been exposed to facts about the case that would otherwise have been inadmissible.
oh, I don't agree with that, Your Honor. Jurors constantly saying, when they've been told not to talk about the case, talking about the case and saying he's guilty, And being exposed to that when you already have all of the social media presence that's involved in this case, that's improper. And again, the fix was easy. When they weren't sure in the third group of 50 whether or not they were going to finish, the clerk said, we have another group of 50 downstairs. How easy would it have been for the judge to say, wow, I mean, he was mad, you could tell. I'm frustrated. They're not following my directions. They're lying.
Couldn't we have sidestepped some of the speculation?
Ah, of course, as soon as I step out of the room, he turns up. Hello, hello. Mr. Udahef, good, you're all here now, so you can watch this. Thank you. Thank you very, very much. Thank you very much. Thank you very, very, very much. Actually, where can I add? Let me just add a little bit. Let's add some tunes, shall we? Which one is this one? Okay. Remember this one? That was my first, the very first theme song.
Watching courts and trials, criminals at best, where the gavel drops and the defense rests. If you love true crime and you
I agree.
want the best, won't you find the time and the defense rests?
All right, that's enough of that. Yeah, I was actually compiling like an evolution up to now with all the previous themes and shit. So thank you very much. But you do realise, you three, you've now doxed yourselves because you put your you sent it with amongst one another. So I have all your addresses. So thank you very much. It was very much appreciated, and the messages were beautiful. It was very nice. Don't do it again. You ruined my makeup.
I think it's clear that this 50 was tainted. And if you go back to the Manning case, what the Florida Supreme Court said that every reasonable step should be taken to preserve a defendant's trial by an impartial jury. And to this end, if there is a reasonable basis shown, the court should take action. There's, without question, a reasonable basis. We have one juror that said, you living in Tallahassee, you'd have to be under a rock to know about this case. Another juror said, the impact that this had on me, when you hear about this, it sticks with you. We have so much about this case, but then when you boil it down to that middle 50, and we know that there's not one, not two, 4 different jurors that has disclosed that they've been talking about the case and is getting the judge frustrated. He has to re-admonish them, but he doesn't go back and question the ones that have already been questioned about whether or not they've heard discussions from other jurors. And 4 of those jurors who were never questioned ultimately sat on this jury. That's a reasonable basis for the judge to have taken the easy step. You're right. At this point, I'm frustrated. They're not following my instructions. 51 through 102, they're done. Let's bring.
What do you reckon? Do you think that's a fair argument? 40% of them potentially biased. Do you think that he should have gotten rid of the middle 50? I want to hear your opinions on what you think their argument, if they've got a valid argument. Does the law actually is there a precedence? Have they proven that his rights have not been preserved, or is he blowing smoke up your ass? I want to know what you think. Let me know. I was had next time everything up there to New York so I can write. Yeah. You'll have to share your addresses, but not on here. Do it in Discord. Blowing smoke. Why am I not surprised?
Up the next 50, I will be very clear going forward. He was, and if we need to go to the 4th 50, we will. That's what should have.
Do you know what the thing that she was referring to before the code? I think it was, what is it, 2158 or something? And I wouldn't mind actually looking at the law that he's referring to, that actual that case. What was it? Let's have a look. Should have written it down.
One, not two, 4 different jurors that has disclosed that they've been talking about the case and is getting the judge frustrated. He has to re-admonish them, but he doesn't go back and question the ones that have already been questioned about whether or not they've heard discussions from other jurors. And 4 of those jurors who were never questioned ultimately sat on this jury. That's a reasonable basis.
Oh, sorry, but was he? Oh, thank you. You're a legend. Thanks, Sonia. But was he given that option? Because the judge at the end of it said, well, you haven't put in your paperwork, so you don't have an option. Was he given that option?
For the judge to have taken the easy step. You're right. At this point, I'm frustrated. They're not following my instructions. 51 through 102, they're done. Let's bring up the next 50. I will be very clear going forward. He was. And if we need to go to the fourth 50, we will. That's what should have been done. And because of that, my client didn't get a fair trial. I'll reserve my last minute for rebuttal. Thank you.
And I will extend you an additional 3 minutes.
I think that was a reasonable argument. I haven't seen the laws or the thing, but if he's presented that well.
And the same for the state, so you'll have a total of
Sure.
8 extra minutes.
He's he's the epitome of like stop self snitching, dickhead.
May it please the court. My name is Charlie Lee.
Absolutely, but did they make it up, or are they actually? Do they have a valid point? He is definitely a good appeal. Yes, his argument is compelling for sure.
I work for the Attorney General's office and I represent the state of Florida in this case. I'd like to start out with the questions the judges here have asked today. One thing I do want to clear up is the preservation issue that Mr. Adelson claims in Manning in his reply brief. He talks about that in that case, the attorney below never filed a written motion, didn't renew his objection to the jury or anything like that. Those facts come from the dissent in Manning. The 3 justices of the Florida Supreme Court who felt that Manning should not have his conviction overturned, who felt he did get a fair trial, noted that his attorney affirmatively accepted the jury. Now from Manning, we've come to Armstrong. And Armstrong is backed up by all the cases where we have Batson challenges. If someone files a Batson challenge saying they didn't have a fair jury because of the demographic makeup of their jury, if they affirmatively accept that jury, then they've affirmatively waived that objection. They have to do it once again. They cannot accept the jury like Mr. Adelson did twice to his jury and to the alternate jurors.
But isn't really, change of venue is not the same as failure to renew specific challenges to specific jurors. It is a much broader, as Mr. Efferman was talking about. It has to do with what was known by the community. It's whether the community is one that cannot hear the case. It's not necessarily about individual jurors. So why should we apply this rule that I understand what Armstrong says, but I've also read Joyner, and I know that that's where the Supreme Court first made this rule very, very clear, and they made it in the context of challenges to particular jurors. Why should we apply? Forget what Armstrong says. Why should we apply it?
You should apply it because it is about individual jurors. Because Mr. Adelson, he's entitled to an impartial jury. He's not entitled to an impartial community or city or world. There are people out there who are going to prejudge Mr. Adelson's case. There's people out there that will prejudge every case. In every jury selection, there will be jurors on the panel that will say that they believe the defendant's guilty just because he's sitting in the defendant's seat. That happened in Mr. Adelson's case. It'll happen in every case that's tried this week at the Leon County Courthouse. It has to do with the actual jurors. One of the things that Mr. Adelson brings up in his reply brief is structural error, and I'm going to explain why this isn't structural error, although Mr. Adelson has waived that because he didn't bring it up in his initial brief. But let's look at the 12 actual jurors that served on Mr. Adelson's jury. Adelson accepted all 12 jurors during the pre-screening phase. All 12 said that they would be fair and impartial. Mr. Adelson gives us no reason to believe them. As Judge Thomas pointed out, there's not a clear record here of why we shouldn't believe them. And Judge Rowe pointed out, because affidavits weren't filed in this case, we don't know what
Right,
the
sweetheart.
pretrial publicity is. This isn't like Shepard
Love
v.
you too.
Maxwell. This
Love you,
isn't
Mom.
like
Thank you.
Irvin v. Dodd, where, Mad Dog Irvin was in the press, as serial killer in the press all the time. It's not like those cases. We don't know because Mr. Adelson didn't file a legally sufficient motion.
But he did show.
All right, so that is the case law they're referring to. I found the front cover. I'm just looking for the rest of it.
Partial. Now, there's much of jurors might be lying about whether they had the exposure. Is it also possible that jurors were lying that they couldn't be impartial and absolutely thought he was guilty to get out of jury service? I mean, I think there's a lot of speculation going on here that we really can't get to.
Well, that's where I point to Singer, a case that Mr. Adelson relies upon. And in that case, and this is a 1959 Florida Supreme Court case, they said that the Florida Supreme Court said they had some doubt as to the impartiality of a fairly large number of the veneermen, which might be indicative of the inhabitants generally of the community. But we cannot determine error on doubt. That's the Florida Supreme Court in Singer.
So would it have been different, for instance, if Mr. Adelson had brought forward evidence that there were 100 broadcasts on the Preston Scott Show, that there were 200 pieces by WCTV, 300 articles in the Democrat, 50 podcasts and court TV programs, and that all of the speakers in those programs, or some high percentage of them, pointed to guilt for Mr. Adelson? Would that be different?
It might be different. All we have is secondhand knowledge of the jurors that were there. That's all we have.
Yeah, well, they didn't submit an affidavit, so it didn't give them any context as to what was inside what the podcasts or the social media they actually observed. There could have been something that was totally the opposite they watched that was supporting him. So, yeah.
It might be different. We have, I think the court TV host is the only one that we know expressed a negative opinion.
And even the jurors who were interviewed about their exposure to the media sources I just listed, some of them found that those sources.
Is that a case in a current trial? Is Tepe write down the full name of the case and I'll have a look for you if you've got a case number.
Were credible, and some of them found that they weren't credible. They called into doubt whether the person who was on one of the news programs was partial or not, right?
Correct, Your Honor. And as to Mr. Adelson's numbers, I disagree. I noted he quotes 29 jurors in his initial brief. I noted 22 that said they couldn't be fair and impartial. But even saying it's 40%, which I believe is what he's arguing today, that's a far cry from Irvin, where it was 2/3 of the jurors had extreme bias against Mr. Irvin. I mean, he was a serial killer that in the press, I believe several states had, sheriffs had said that they were going to make sure that he died, was executed. One of the cases, Murphy, and I do agree with Mr. Adelson, there are some similarities between issue 1 and 2. And moving on to issue 2, we have to give jurors credit. Just because this young man said that Mr. Adelson was guilty, and another man may have forgotten what he posted on Facebook about Mr. Garcia, that doesn't mean that the entire jury pool was tainted. As Judge Thomas pointed out, the defense counsel was given an opportunity to go back and review video of the courtroom or the jury assembly room wherever this happened. They were moved from the jury assembly room to courtroom 3G, and the defense declined. So we don't know. There's no indication that this young man stood up on a chair and yelled this out at the jury pool in general, or whispered it to someone. We don't know. as far as the gentleman with the Facebook page, we don't know exactly what he posted about Mr. Adelson, other than he said something about surprise, surprise. And the defense counsel didn't establish a record. And again, going back to Singer, we're not going to reverse this case based on doubt. This isn't a case, because this is not a structural error. And neither the U.S. Supreme Court nor the Florida Supreme Court has ever held that a failure to change a venue, or denial of a change of venue motion, or prejudice within the community, or biased amongst prospective jurors has ever resulted in structural error or per se reversible error.
Didn't the Manning court, though, suggest that a venue error is a structural error?
I don't think so, Your Honor, because they looked into, the majority in that case looked into the individual facts, case by case. When we get to Rawling, there and McCaskill, there the courts, and it came long after Manning, they've developed a test to find out. And this is why, in this case, we had two voir dires. We had the pre-screening process and then the actual voir dire, which is, far more than the average defendant gets. And that's so we can suss out and we can identify prejudice amongst those jurors, because no court has ever held that, bias amongst jurors in the jury pool would result in a structural error.
You put too much faith in me, and by Jody you mean Tanya. I said to her last night, "This is all your fault." She's like, "What? What's my fault? What have I done?" I said, "Well, if it wasn't for you, I wouldn't have found Tyre. If it wasn't for you, I wouldn't have found Devil's Advocate." So it's all her fault.
Because that doesn't affect the framework. Now, if there was something inherently wrong with the voir dire process, perhaps. Now, no courts held that either. But in this case, there was no problem in the voir dire court. The judge here went above and beyond by having the pre-screening process, then the voir dire, where counsel will get an extra chance to challenge jurors. One of the things in this case is the defense counsel didn't ask for any extra peremptories. He didn't even use all 10 of his peremptories until the very end of the voir dire process, which is a factor in Manning. And it's
So did they not use all their preemptive strikes, the defense team? Is that what he's saying? I don't understand the argument. We just back that up a tiny bit to rehear that.
by having the pre-screening process, then the voir dire, where counsel will get an extra chance to challenge jurors. One of the things in this case is the defense counsel didn't ask for any extra peremptories. He didn't even use all 10 of his peremptories until the very end of the voir dire process, which is a factor in Manning. And it's why we have those factors, is because with structural errors, those are errors that are so, such as a right to an impartial judge. It's not like we can question a judge, or the right to a defendant's right to represent themselves. We can't question a defendant about why he wants to do that. Or a public trial. If there's no public trial, we don't know what happened. We can't peer in. We can't look behind the veil and see what that error might have caused. But in this case, it's perfectly clear. Mr. Adelson agreed to 58 jurors. The jurors that served on his jury, only one of them heard another juror talking. 3 of them had no prior exposure to the case. And all of these jurors, Mr. Adelson agreed to.
Could you address, preservation issue aside, let's go to, can you address Mr. Ufferman's fundamental error argument?
I don't think that he can show fundamental error, because he can't show that in any other venue that Mr. Adelson would receive a fair trial. This case, in modern cases often, fair trial, a different trial, a different result. Fundamental error requires the defendant to show that a different result, but for the lack of change of venue, that his case would have ended up differently. Well, that's not the case here. There's been no demonstration of that.
So it's not just fundamental error that he didn't get a fair jury. Wouldn't that be fundamental error in and of itself, regardless of what the outcome of the trial was?
Well, if he could show that he didn't get a fair jury, but he certainly did.
Well, that's his claim.
Well, it's his claim, but he hasn't shown any evidence of it. He hasn't shown why this particular jury, these 12 jurors, were so biased that, that the outside influence on these jurors would have changed their verdict. He's made no showing of that whatsoever. He didn't try to poll them. I mean, they polled them after the trial, but he didn't try to question the jurors or anything like that. There was a motion later, but there's no evidence in the record that these jurors were influenced. Like I said, 3 of them had never even heard about the case. So there's no evidence in the record whatsoever that his actual jury, because he has a right just to a impartial jury, that they were influenced by the media and the local, the conversations around Tallahassee influenced their verdict. There's nothing in the
I think
record.
his argument is that the media saturation implicitly biased the jurors, I think is one argument. Maybe another argument is that they are lying. They were lying when they said that they could be impartial. And he's pointing to the 2 jurors who did in fact lie. And then again, he points to the 53 of the 54 jurors who were excused for cause because they had consumed the media and felt that they could not be.
Yep, that's a fucking good attitude to have. Absolutely. Correct, 100%.
Impartial in this case. So that's the evidence he's pointing to. What do we do with that?
Well, Mr. Adelson's asking this court to presume prejudice there, which is something that this court could only do under a structural error argument, which he's waived, and no court has ever held that it's a structural error. This court should not presume error, and Mr. Adelson has not proven any error. He hasn't proven by not filing a.
See me drop his link in chat, darling. We help. More than happy to promote channels that are doing the right thing and, reporting it with honesty and not bullshit.
Legally sufficient motion with affidavits that show what the media coverage was. We had that in Foster. In Foster, the defendant there filed, news clips, articles that were far more negative against Mr. Foster than anything that we heard. All we have is secondhand accounts from other jurors or prospective jurors about what the media, publicity was. But assuming what they said was true, what happened in Foster was far worse, and what happened in Rawling was far more extensive. And this court, there's no reason this court should presume prejudice. And if, there's no reason this court should find prejudice if Mr. Adelson hasn't proven it, and he has not.
Well, Mr. Adelson argued in the brief, or counsel argued in the brief again, that the media environment in the Rawling case in 1994 is substantially different than it was when Mr. Adelson's case went to trial. What do we do with that?
I don't think that's necessarily true. We don't know much about Mr. the media coverage around Mr. Adelson, but in this day and age, no media is really local. And in this case, there was over the My Dead Body podcast, there was national news. People were following this all over the country and all over the world. The environment hasn't really changed. Really, the important thing is local sentiment. If it's something that shocked the community, this is as bad as Dan Markel's murder was. 30 people on the jury, prospective jurors, had never heard of the case. In a town like Tallahassee, where people are coming and going quite a bit, it's even less than, in Gainesville, sort of the same situation with Rawling. But in Foster, that murder there with the extremely negative publicity didn't warrant a change of venue. And Foster was after Rawling. So I don't know that I understand Mr. Adelson's arguments at times have changed, but I don't think people have. It's when we do go to pick a jury, we ask jurors, in that community, can they be fair? What have they heard? Can they set these things aside? Because after all, that is the standard in McCaskill, not whether they've been exposed, but whether they can set aside that exposure.
Does it, as long as we're talking about distinguishing the Rawling case, does it matter that we have a notorious murder and we have a lot of media from it? In the Rawling case, we had a literal serial killer on the loose, killing people. I don't think anybody in Tallahassee believed that somebody was going to pay Garcia and Rivera to come up to Tallahassee and kill them. That was not an.
Just thought I'd share this 1 second. That's what Sonia, my lovely helper, just made me for lunch. And there might be a card behind that. Don't know what you're having, but I'm having this. Nope, wrong one. Nope, wrong one. There we go. Third time lucky.
Rational belief in Gainesville when there was somebody who literally was brutally killing people day after day for a while. That has nothing to do with the media coverage. That has nothing to do with what was happening in 1994 when he was being tried. But does it have anything to do with the decision of whether to change venue when you have something well beyond the media in assessing how the community may have felt?
I agree, Your Honor. In Rawling, the Associated Press described him as the next Ted Bundy, basically. And there is that fear and that shock. And I don't want to downplay Professor Markell's death. It was shocking. It was terribly sad. But you're right. It was certainly figured out that this was a murder for hire. And by the time that Mr. Adelson went to trial, this court had already affirmed Garcia's conviction. This was a murder for hire plot. The people in the community were not at danger as they would have been with Rawling or Bundy or even Foster with his Lords of Chaos group. I agree with Your Honor that when that fear stays in a community, that can certainly poison their minds. But in this case, that fear that would have been there in Rawling and Gainesville in the 90s would not apply to Mr. Adelson's case. And like I said, it's not surprising that only 22 jurors said that they could not set this out of their mind. I know,
Isn't there a difference here, though? I mean, unlike the Rawling case, there's been, now 12 years of sustained media coverage. There have now been 5 convictions in this case, and at the time of the trial, there had been 3 prior to Mr. Adelson. Doesn't that make a difference?
I think it can work both ways. I think the saturation and the fact that this case has been going on for so long may dull the senses of people. They hear about it, they get disinterested the more they hear. I mean, but I think one of the factors in Rawling is the time of the publicity and the trial itself. In Mr. Adelson's case, the crime was far removed. 9 years, as one of the jurors pointed out, prospective jurors pointed out. But the nature of the coverage matters a lot too, and the nature in relation to the time of the trial. And there's nothing in the record to indicate there was negative publicity about Mr. Adelson around the time of his trial.
Have a look at that. 1 second. When he makes that argument.
Hear about it, they get disinterested the more.
Yeah. So, hang on. Oh. Have a look at the defense attorney's face when this attorney starts talking about, you've been exposed to it for so long, your interests are dulled.
Or both ways. I think the saturation and the fact that this case has been going on for so long may dull the senses of people. They hear about it, they get disinterested the more they hear. I mean, but I think
let's just assume that will be brought up in his rebuttal.
one of the factors in Rawling is the time of the publicity and the trial itself. In Mr. Adelson's case, the crime was far removed. 9 years, as one of the jurors pointed out, prospective jurors pointed out. But the nature of the coverage matters a lot too, and the nature in relation to the time of the trial. And there's nothing in the record to indicate there was negative publicity about Mr. Adelson around the time of his trial that would influence the jurors to reach a guilty verdict instead of an innocent, or sort of acquitting him.
And again, that's perhaps where an affidavit may have come in to help the defense in terms of how many media stories there were within the relevant period, the content of those stories. Again, we don't have that in the record. We just have sporadic references in the record where jurors were reporting that they had seen some media at some time.
I'd argue it's why the rule exists. It's why the rule requires
as long as we're talking
affidavits.
about the rule, counsel, I noticed, Armstrong talks about how a change of venue motion is premature until there's been an actual attempt to impanel a jury. I understand what they're getting at just on its face, but I'm having trouble understanding how that requirement it plays into the requirement that there be a written motion for change of venue. Do you try to, do you attempt to impanel a jury, and then when you can't, you say, hold on, Your Honor, give me a few minutes so I can write out a motion for change of venue because the rule requires it to be in writing? In other words, is the requirement to be in writing unrealistic given the separate requirement that a motion is premature until you attempt to impanel a jury?
No, Your Honor, the rule is not unrealistic because it requires the defendant to make the initial record that he needs to make. And that is, if you file it before, if the defendant files the motion before trial and has the affidavits, which he should, like some of these cases, they went around town doing polls. And in Foster, they got the news coverage and everything before the trial. So it incentivizes a defendant to go out, get the information, poll the community, make the record for their motion, file the motion ahead of time. The court's under advisement that this is an issue, which in this case, it was an issue even before jury selection. The court then, the judge in this case, then wisely took the effort to have a pre-screening process and a voir dire. And so the rule is not unrealistic. Now, the Florida Supreme Court says that we have to go ahead and try to pick a jury anyway to see if we can determine whether there is a bias within the community that can't be overcome, but we have to test that. That's one of the reasons I'm arguing it cannot be a structural error, because this is something we can palpably test. And so that's why I believe it's not, the rule makes a lot of sense that it requires a pretrial motion with the affidavits. To conclude, I'll move on to issue 3 briefly. I think in this case, one of the things I want to argue about the evidentiary issues is Mr. Adelson's, when he brought his text messages to the court, he never took the opportunity to untangle them for the trial judge. And the trial judge should not have been required to do that for Mr. Adelson. And that's why I'm arguing it's not just unpreserved, it's an invited error, because when the trial judge asked Mr. Adelson, if you can get some texts for me that are relevant, that would show what you're trying to prove, he just said all of them.
But that is their argument. Their argument is all of them should have been admitted, not 1 or 2 that the judge might find relevant, but all of them. How can you waive that argument simply by refusing to cherry pick ones?
Because the only relevant arguments would have been if there were any relevant. I argue that even these weren't relevant, but the conversations between Meg Benoit and Donna Adelson and Wendy Adelson, he didn't separate those out and offer those to the court and say, these are the relevant text messages and this is why they're relevant. He should have done that. The judge was under no obligation to untangle those for Mr. Adelson.
And I think there was concern about the content of the message. I think you characterized the messages in your brief as racist, misogynist, and sexist. And I can imagine that had those been admitted, Mr. Efferman might be right up here arguing unfair prejudice against his client because of this bad character evidence.
Correct, Your Honor. The judge has to act as the gatekeeper of evidence in every case. And in this case, we may have very well had an ineffective assistance of counsel in the face of the record argument had the judge not asked pointed these things out to Mr. Adelson and asked him.
Is it really the judge's job to protect the defendant from himself, though? I mean, if counsel believed that the strategy included admitting these text messages that might otherwise be viewed as negative to them, isn't that really a strategic call on counsel's part?
If it's a strategic call that no reasonable attorney would take, I think a judge does have to step in. A judge will have to step in even under a 403 analysis, if something's more prejudicial than probative. In this case, those texts were certainly more prejudicial than probative. Yes, a judge should step in.
Even if it's prejudicial to the offering party?
Yes,
now, I'm not going to allow you. I think that would harm yourself if you admitted that. So I'm not going to allow that evidence in. I don't think I've ever seen that.
I think in the interest of not vitiating the entire trial, a trial judge should do that. And because otherwise, he's letting the defendant walk himself into a mistrial, and a judge should not allow that to happen or be forced to allow that to happen. Based on those arguments, Your Honors, I would ask this court to affirm Mr. Adelson's conviction for his part in the murder of Daniel Marco.
May it please the court. I'll begin by briefly addressing claim 3. Here's why it was so prejudicial to my client to not get in the other text messages that the state was pointing to and suggesting that they had to have been about nefarious things as opposed to routine things. The text messages that have been proffered, they clearly are routine things. This is what the prosecutor argued in closing, page 2082. Quote, but as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about murder or if these call flurries around key events are just coincidence? A conspiracy can be shaped like blah, 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 and she goes on. Without knowing the content, the state objected to the jury being able to see all of the content. And now they seize upon that in closing argument and say,
I'll ask you the same question I asked the state. I mean, if these messages, which were labeled as racist, misogynist, and sexist, had been entered against Mr. Adelson, wouldn't you be arguing here that the jury was prejudiced against him in terms of this bad character evidence?
absolutely not. Number one, that would be the actual definition of invited error. Number two, my client would be, I'm sure he's not great, but he can take the label of being racist, misogynist, whatever else. He doesn't want to take the label of being murderer. And these texts would have helped him show that what the state was arguing is not true, so much so that the state seized upon it. He doesn't need protection from himself, as Judge Winokur's already indicated. He has a right to put on evidence that he thinks is relevant. Mateo says any evidence that could be in any way, even in a slight way, relevant to the theory of defense, a judge errs in not allowing it in. The purpose of putting these texts in is not, as the trial court was saying, oh, do they go to motive or they go to any element of the crime? No, they go to showing that these are routine communications, not what the state is asserting. And he was prevented from putting that in, and the state seized upon it in closing.
Was this, if there was error, is it not harmless? He was allowed to testify about these texts on the stand.
Wow, my client was out on an island in this case. There's no question that it was, one other witness was presented. My client's testimony. Is there anything to back up my client's credibility? This would have been something that the jury could have looked at and said, wow, Mr. Adelson saying that, well, he didn't do this. He didn't hire these people. He's the one actually being extorted. But there's nothing that supports that other than his testimony. This would have been, wow, look at the text messages. See them for yourselves, ladies and gentlemen.
How was your client on an island? I mean, certainly he could have brought forward the mechanic he was having the conversations with and all of the other people to testify about the kind of communications they had with your client.
You all know very well that I think defense counsel was ineffective and had a conflict of interest. I'll raise that at another date should I need to.
But it's clear that your client was not on an island, that there could have been evidence presented that would have corroborated what was in the text message.
I agree, and the judge prevented it. That's the whole reason for claim 3.
Counsel, I want to go back to something that we talked about at your initial argument about what needs to be shown to strike the entire panel. Now, I did look and I saw that this wasn't cited in any of the briefs, but I'm going to say it anyway. It's Morris, Florida Supreme Court from 2017, and the quote is, for the statement of one veneer member to taint the panel, the veneer member must mention facts that would not otherwise be presented to the jury. So is that the correct standard to be used in striking an entire
I
panel?
think that's one aspect of it, and I acknowledge that's not met in this case. Clearly, the facts that were discussed did come out during the trial. I think the bigger issue is the expression of guilt. So I think the case that's closest on point is Brower, cited by the state. And Brower, the comment that was being made by a particular juror was they should just hang him. And this is what the 4th DCA went on to say. This is on page 1027 of the opinion. The offending members of the veneer were facing a 3-week murder trial and were enduring a tedious and lengthy jury selection process. They certainly used poor taste and worse judgment. However, there is nothing in the record to indicate that the offensive remarks were.
All right, what is shit on a shingle then? The kids call it Poop on the roof. Oh my Lord. Blood shit in a shingle. Please explain.
were offered or taken seriously. The 4th DCA's finding that the comment, he should just hang himself, was literally a joke, not an expression of the defendant's guilt. That's not at all what we have in this case. I see them into my, over my rebuttal time. I would ask this court to reverse, and I would end with this. If there was ever a case for a change of venue, these facts are that case. Thank
Counsel,
you.
my colleague has a question,
Oh, of
so
course.
I'm going to extend your time for her to ask it and you to answer it.
Thank you.
And appropriate, your last sentence said on the facts of this case. And that's what bothers me. And I would like a response from you. The fundamental error argument. In this case, on this record, we're arguing speculation. If you're arguing fundamental error and you're asserting speculation of prejudice by the jury, in practical application, you're lowering a fundamental error standard below even abuse of discretion to me. So, on this record, your argument on fundamental error to me, I guess, help me understand what more than speculation is backing up your fundamental error argument.
Yes, Your Honor. And it would be, and I know that you mentioned, but I will go and I have them written down right here. 40% of the jurors had formed of the 130 belief that my client was guilty. Only one had not, or thought that my client was innocent. 3 prior cases, as has been discussed, and one of those cases was 2 trials, one of which occurred a year before. 10 years, almost a decade, this case has been going on in this, as the judge said, small community. 2 jurors lied. So it's not just speculation. If I was suggesting that, based on this, we can suspect that some.
And how do you account for all those unknowns, like the jury lying? The context not given. How do you evaluate that?
Jurors are not willing to tell the truth and really tell the court that they've already formed an opinion. We know 2 jurors lied. One of those, well, both of them lied and specifically had an opinion about the case. And ultimately, the jurors directly violated the court's order and talked about the case, even though the court specifically said, don't do it. When you consider all of those factors.
We call that mince on toast. Savory mince on toast. I suppose it's got the same initials.
In their totality, we establish fundamental error in this case. Thank you.
Thank you, counsel. Thank you both. This court is adjourned.
All right.
All right. Have you all, sorry, it's a mouthful. Have you all filled out your poll? What are we up to? All right. So, poll results. Did Charlie receive a fair trial? 60% of you said yes. It's time to sit down, Charlie. 20% of you said yes, the attorney is full of shit. 20% of you said no, his attorney made great arguments. And no one said the jury pool was tainted. Well, there you go. Now, I have that Armstrong ruling, and I have just run it through my database to see how strong their argument is against that. All right, so let me see if I can share this. It's hot off the press right now. So what I did is basically I copied the whole court ruling, uploaded it, and then asked the question, analyze this court ruling and apply it to evaluate the strength of the arguments put forward in Charlie ADELSON's appellate hearing online for a new trial. All right. So you have the question. Now you have the answer. Let me just get rid of this shit so you can all read it. How do I close that down? Okay, there's one. Just make it bigger for you. Now, I haven't read this, so So I have no idea what it says. That shit. Get rid of it. Yeah. Just gonna have to put up with that one, I think. Sorry. All right. Can you all read that? No, you can't. Oh, I love it, Jenny. I love it. You've got no idea how much I use it. No idea. Yeah. Yeah. All right. So, I wonder if I can. Hang on. Yeah. See if I can get this working. Pronunciation. Oh, Christ, no. No, just no. Just no. Oh. All right, let's see if it'll work now. Come on, why aren't you? Ready, please, Mr. Music. On you. Come on, you useless piece of shit. The fuck? Bugger. That'll teach me being lazy, won't it? I can't eat and talk at the same time. I'm good, but I'm not that good. That better? Get rid of that. Because you're useless. Useless. Oh. What? Go away. Go away. Fuck me. Now it won't piss off. I don't know how to get rid of it now. Ah, okay. There we go. All right, analysis. Core legal principle, tactical waiver doctrine. The Florida Supreme Court establishes that a defendant waives the appellate claims of error when the defense counsel affirmatively requests the action they later challenge on appeal. 2, the request constitutes a tactical decision, not a fundamental constitutional right requiring a personal waiver. And 3, this prevents the defendants from intentionally injecting error into the trial and then awaiting the outcome with the expectation that if he is found guilty, the conviction will be automatically reversed. Key holding from this is it is not fundamental error to convict a defendant under an erroneous charge when he had an opportunity to object to the charge and failed to do so. 1. The improperly charged offence is lesser in degree and penalty than the main offence. Or 2. Defence counsel's requested the improper charge or relied on that charge as evidence by argument to the jury or other affirmative action. Charlie ADELSON's appellate arguments. Based on the appellate hearing on the 3rd of February, well, that's one, for Judges Rowe, Winker and Thomas, ADELSON's attorney Michael Ufferman advanced the following key arguments. 1. The change of venue. The trial should have been moved from Tallahassee due to persuasive pre-trial media coverage. 2. The jury bias. The seated jury was inherently biased due to media exposure. The jurors were overheard discussing the case. 3. Conflict of interest. Attorney Daniel Rushbaum had actually conflict that represented both Charlie and his mother, a co-conspirator. And 4. The evidence exclusion. The judge erred in refusing to admit text messages and a recorded phone call with Donna ADELSON post-FBI bump. Okay, so let's apply that to each of his arguments. Change of venue. State's position. The appellate court explicitly challenged Ufferman's arguments by noting that under Florida law, a formal written motion to change venue must be filed after the jury is seated, but before they are sworn in. To apply that rule to this ruling of this hearing, the prosecution, through Assistant State Attorney Charles Lee, argued that the defence waived this issue by accepting the jury without voicing an objection. So he didn't preserve the record. Fuck. Okay. Where was I up to? Okay. By affirmatively requesting the instruction, he now challenges Armstrong has waived any claim of error. Critical exchange at hearing. Ufferman argued the defence never waived its objection to the jury. However, he concedes that if the court found waiver occurred, they should treat it as a fundamental error and eligible for reversal. Oh. Armstrong's counter-analysis. The Armstrong court specifically rejected the notion that fundamental error claims can resurrect waived issues when the waiver resulted from tactical decisions. The court noted that distinguishing Aiken v. State, where relief was granted, only applied because the defendant had been convicted of a non-existent crime, a circumstance not present in the ADELSON case. So the strength of that argument is given a 30% weak argument for appellate. Oh, here we go. We have a score. The defence's failure to file a timely formal motion or object before the jury was sworn constitutes tactical acceptance under Armstrong. Florida's appellate courts have consistently held that failure to preserve issues at trial precludes appellate relief except in narrow circumstances. Argument. Oh, did I miss an argument? Maybe it's skipping one. Oh, that's argument 1 and 2. Okay. Change of venue and jury bias. So that's got a 30% success rate, according to Mr. Drive here. The conflict of interest is Rushbaum representing both parties. So Ufferman argued that Daniel Rushbaum's representation of both Charlie and Donna created an actual conflict of interest that infected Charlie's trial. Rushbaum responds that Donna ADELSON, before Charlie's arrest, Donna was initially listed as a defence witness, but was removed to avoid state interviews. The decision allegedly prioritised Donna's interests over Charlie's. So how they've applied that. This argument is partially distinguishable from Armstrong because Armstrong involved tactical instruction choices. Rushbaum's conflict involves constitutional Sixth Amendment right to effective counsel. Armstrong specifically excluded fundamental rights. The ruling noted that a waiver of a fundamental right requires the defendant on the record waiver. And 3, the court cited that State v. Griffin to distinguish tactical decisions from constitutional waivers. However, The state counters. In January, the first DCA denied Adelson's motion to relinquish jurisdiction to the trial court on this conflict issue. Charlie himself declined to waive the conflict when asked during Donna's trial proceedings, and this creates the question, did Charlie's silence during his own trial constitute acquiescence? The strength assessment, moderate, 50%, 50-50. Ooh, we got 50-50. Wow. This is Adelson's strongest argument because conflict of interest claims touch on Sixth Amendment rights, which Armstrong specifically carved out from its waiver doctrine. However, the procedural posture motion, already denied in January, and the fact that Charlie was not directly harmed by a fundamental constitutional deprivation weakens its prospects. Argument 4, evidence exclusion. All the hundreds of text messages that Charlie and alleged co-conspirators between. All right, so evidence rulings are typically discretionary trial court decisions, reviewable only for abuse of discretion under the Armstrong's logic. If the defence counsel failed to make proper proffers or objections preserving these issues for appeal, the waiver doctrine applies. If counsel made tactical decisions about what evidence to emphasise, those choices cannot later be used as appellate grounds. The considerations are that the state's answer brief asserts any Florida jury would have convicted Charlie Adelson for effectuating the murder of Dan Markle. This confidence suggests the state believes the evidence against Adelson was overwhelming, making evidentiary errors, if any, harmless beyond a reasonable doubt, another doctrine that works alongside Armstrong to deny relief. Strength of this assessment is weak, 25%, so evidentiary appeals that face significant hurdles and Armstrong's waiver principles make this even more difficult if proper objections weren't made or if the exclusion resulted from tactical decisions. So there's your assessment. So the change of venue argument is weak. The jury bias is weak. The strongest one is the conflict of interest. There you go. Conclusion. Armstrong v. State significantly undermines Charlie Adelson's strongest appellate arguments. The change of venue and jury bias by establishing that tactical decisions and failures to object to trial constitute waiver of appellate claims. The only argument that survives Armstrong's waiver is the doctrine, Armstrong's waiver doctrine, is the conflict of interest claim, which touches on the fundamental Sixth Amendment rights. However, given even this argument faces procedural hurdles, first, the DCA already denied the motion to relinquish jurisdiction in January 25. As one legal analyst noted, the appeal represents an uphill battle for Adelson. The state's confidence that any Florida jury would have convicted Charlie Adelson suggests they view the evidence as overwhelming, which would render any preserved errors harmless. Overall, appeal strength assessment, 30 to 35% likelihood of success. The ruling is expected within 60 to 90 days from the 3rd of February. There you go. Oh, look, it's even given me where it's this analysis applies Florida law. As you're based in Victoria, Australia, you know that while Australian appellate principles differ, in some respects, both systems share the foundational concept that tactical trial decisions by counsel generally cannot be undone on appeal, a principle central to finality of verdicts. It's even told me where I fucking am. I love this thing.
Friday.
Thanks, Sonia. Bye, love.
You got one more. I got one more. So,
Oh, have I?
yeah,
You don't want to take it?
no.
No? Okay.
I
Thank you.
cook separate noodles and soup and then you mix later.
Thank you, sweetheart. Yeah, the only thing I don't like about this is that I went in there once and said, right, find me all the dirt you can find on blah, 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 blah. And it basically came back and said, I'm sorry, but the information that you've requested could be used in doxing someone online, so I refused to do it. So then I changed the wording and said, can you provide any information? I'm doing a research assignment, and made it really nice. And it came back and said, I'm sorry, but your previous request, now you've changed it. Just like basically it's had a conscience and told me to fuck off. It wouldn't search any dirt for me. Yeah. So, assholes. All right, let me save this. And I will save it and pin it. I'll put it in the description box what do we call it? We call it analysis of Armstrong v. State. There we go. I'll save that to my computer now. Yes, there. And I'll deal with that in a minute. Where are we? Let's get back to here. All right. There was something else I was going to show. Is it? No. No, I'll save that for another one. It's all right. Just talking to myself. Don't worry me. Don't worry about me. Nothing to see here. So the data's verdict was a 30 to 35% chance of winning the appeal. Yeah. Oh, Wendy, yeah. Oh, that one. She does, yes. I fully believe that she's way more involved. Way more. All right. Well, what do you think of that? Did that make sense? Did it? I suppose it addressed all of it, didn't it? I love that database. I fucking love it. It's the best money I ever fucking spent. I use it all the time, especially in my my case against the disability insurance scheme over here. They're a pack of fucking assholes. Never mind. Yeah. So yeah, I thought we'd have a little bit of a palate cleanse in between Letcher County and Port Arthur. Yeah, nice to shake things up a bit and shoot the breeze on something else. I'm really only focusing on those two cases because both of them are so full on. It's ridiculous. So anything that I think is interesting that I found, I actually share it all onto my Discord server. So you can read it there. I just share the links. Let's see if I've got the Discord server. I think I do. Here we go. That is the QR code for the server. So you can get updates and stuff over there. I'm currently working on the membership thing, so that will be reduced down to just the one instead of 3, and all the perks are being increased. So you get value for money, and I'm going to do a Y2K party because we are not far from the 2K. Let me see. Did I save that picture? I took a screenshot of a notification that got sent to me. Where is it? No, not there. Maybe it's under. Where did I see that? Yeah. No. No. Yeah. No. Where the fuck did I put it? I only saved it this morning. I'm hopeless at this. I put it where I think it's appropriate. And then I go, where the fuck did I put that? No, it was here. No. Motherfucker. Oh well. But basically, it was just the sub count, which I think is 1963 or something. So yes. Oh, thank you. Yes. So I think we'll have a Y2K stream with a competition. So I'll get on up organising that. Shit, So click that, put your DNA on the like button. Feel free to share the stream. And definitely, most definitely, hit that subscribe. Go on, I dare ya. Hit it, my balls. It's free. Don't cost nothing. Get it on. All right. Yeah, I can't do the grift. It's just, I'm fucking hopeless at it. Well, if you like your people, if you found your people, then stay with the fam. All right. You came for the crime, you stayed for the fuckery. Love yous all. See you soon. Bye-bye.
Hey there, thanks for stopping in. We hope you will join us again. We all look forward to next time. We get to talk about true crime. Clues. Justice served in an honest fight. True crime tales till the verdict's right. Solving more than just trivial quests, where sentences rule and the defense rests. Our true crime family is great. All types of topics we debate. Smash that like and ring that bell. Hit subscribe, you might as well.